All right. Good afternoon, everybody. Thank you so much for coming and joining us here at Denver Law's remote discussion. We know that everyone is really looking forward to the speaker. We are thrilled that we have him on board with us. So this afternoon, we're going to hear from Professor César Cuauhtémoc García Hernández, who will speak about criminal law and immigration law. And what we'll do is we have May Peterson from the admissions office as well, and we will be listening to professors' discussion, and then any questions that you have, if you would not mind putting them in your chat questions. And when he completes, we will then read those questions aloud for his responses. So thanks very much, and we look forward to having a really riveting conversation, or yes, it will be a conversation in a way. Okay, so thank you.
Yeah.
Professor, if you would say a little bit about yourself, how long
Sure.
you've been here at Denver Law, your background, etc.
All right. Well, thanks so much, Yvonne and May, for inviting me to participate and for juggling this situation. I was originally scheduled to do essentially a version of this talk. Well, I guess now it's almost 3 weeks ago in person for the admitted students open house, and well, I think as for reasons we all understand, that did not happen. So I was really excited to get the invitation to do this by Zoom, obviously from home, just like most of us are doing wherever it is that home is currently for you. Hopefully for many of you, it will be Denver soon enough in a few months after what I hope is a return to normalcy. I've been at DU now since the fall of 2013. So I guess this is now year 7 for me. I taught a couple of other law schools before getting to the University of Denver, and since I've been a lawyer and since I've been a law professor, my focus has always been on the intersection between criminal law and immigration law. And so I had planned to really focus my talk specifically on the research that I've been doing for many years that recently culminated in a book that I published in December called "Migrating to Prison: America's Obsession with Locking Up Immigrants." This is my second book. My first book came out in 2015. That's called Crimmigration Law. But as I sort of reflected on what on this particular version of act with you all, I thought it didn't make any sense to just sort of pretend that the world is the world that we knew 3 weeks ago. If things were the same, I would have had this conversation with you all in person. And so I think it's important to sort of acknowledge that right now and for the last few weeks, the legal community has been obviously responding to COVID-19 on a personal level. All of us are trying to take the measures, or many of us are trying to take the measures that are recommended by the public health community to protect ourselves, protect our families, people in our communities. At the same time, we continue to have obligations to clients, to the legal system, as and the way that is managed. Context of lawyers who are involved with immigration law in particular, is trying to figure out, are courts open? Are the government agencies that decide whether somebody's going to be granted a visa or not still making those decisions? Are they still fingerprinting people for background checks? Are they still meeting with people for interviews, for naturalization? applications. And most specifically to the focus of my research on the intersection between criminal law and immigration law, and the use of incarceration to enforce immigration law. What's happening inside of the immigration prison system that the federal government runs. And there what we're seeing is that, like in many jails and many prisons throughout the United States, these are facilities that are starting to see COVID-19 spreading through employees, mostly so far, through staff, basically guards, who knows how they're infected, but have been confirmed in a number of facilities. And then we're starting to see that that is also that COVID-19 is also starting to appear in some of the people who are actually detained. Meanwhile, lawyers and immigration judges are really concerned about their own exposure, and we're seeing that immigration court cases are moving forward for folks who are detained, and in most of the country, at least. And the people who staff those courts, whether it's defense attorneys, whether it's prosecutors, whether it's immigration judges, or all of the staff that goes to supporting the operation of the immigration court, are really quite concerned. And a rather extraordinary move about 10 days ago, the National Association of Immigration Judges, which is the union that represents immigration judges, partnered with the American Immigration Lawyers Association, which is the largest bar organization of immigration defense attorneys, and also with the union that represents the prosecutors, so the lawyers who represent the federal government in immigration court, to release a joint statement asking that the immigration courts shut down, or at least take steps to reduce the risk of their members being infected by COVID-19, on top of obviously the risk that other folks who aren't necessarily members of those organizations but are in close contact with everyone who is. And so far, there have been some measures, but certainly when it comes to the folks who are detained, the court system is operating, and so COVID-19 is playing out in the same kind of uncertain way in this particular context as it is in every other context. But here we are grappling with a situation in which all of these folks have to show up. They have an ethical obligation. If they're defense attorneys, they have an ethical obligation to their clients. And so long as the government is trying to deport somebody, then lawyers who are representing them have an ethical obligation to show up and put the best legal claim forward. The attorneys who represent the government are in much the same situation, and then of course the immigration judges continue to be obligated to oversee those hearings and continue to issue decisions as the case might dictate. So that's sort of the unsettled nature of things. But to take a step back and talk a little bit more about sort of how this fits into the work that I do and have been doing for several years now at the University of Denver. As Yvonne said, and as I mentioned earlier, my focus has been for many years on reading, on teaching, on writing, speaking about this intersection between criminal law and immigration law that we refer to as crimmigration law. And at bottom, this phenomenon, this term analyzes the merging of criminal law and immigration law norms that have marked legal regimes in the U.S. and across the world now for about 30 or 40 years, different amount of time in different places. And this term crimmigration law was one that was excuse me, articulated first. It was coined really by the legal scholar Julia Stumpf back in 2006, But since then, since she first sort of used this word to articulate what was happening, we've started to see that immigration law has started to solidify and appear quite clearly in three different strands. I like to think of it. First, there's the fact that the number of crimes that can lead to adverse immigration consequences has been growing in the United States and in other countries for about, in the US at least, going back to the mid-1980s. The second strand of immigration laws, I think of it, is this, the increasing amount of migration-related activity that can and quite often does lead to criminal prosecution. And then finally, there are the unique or uniquely harsh methods of regulating the lives of migrants that I think cannot realistically be described as either traditional criminal law or traditional immigration law. And that's why there's some value in adopting a new hybrid term like immigration to develop what is, I think, a new hybrid form of enforcement. And I'll highlight each of these briefly and just to give you a little bit more context. So let me start by talking about where I think immigration law really begins, and that's in the 1980s with an expanded appetite to remove migrants who had committed a remarkably large or growing and remarkably large number of crimes. I mean, that's unusual historically, because historically crime was just punished through the criminal justice system. That was true for U.S. citizens as it was for people who are not U.S. citizens. Legal troubles usually just ended at the conclusion of a criminal prosecution, if it ever got to that point. And in the U.S., as in most countries, most crime is not actually prosecuted through the criminal justice system. Most crime actually just goes unprosecuted at all. That varies based on what kinds of crime, obviously, but by and large, most crime doesn't goes unprosecuted. That in the immigration context, that really began to change in the mid 1980s, when we see the beginnings of what we now know as the war on drugs. And in that period, Congress, starting in that period, it wasn't confined to that period, but starting then, Congress and multiple presidential administrations since then have steadily added to the list of crimes that can result in forcible removal from the United States. Just to give you one example, there's the Anti-Drug Abuse Act of 1988 is an important one in this history that I'm referencing. As the name suggests, it targeted illicit drug activity, the Anti-Drug Abuse Act of 1988. But it also added two little words to federal immigration law that changed the fortunes of millions of migrants. It's this concept called the aggravated felony. So every day since then, immigration lawyers, immigration judges have grappled with the evolving state of the law about what is an aggravated felony, not an aggravated felony, and about the consequences. Somebody who's been convicted of an aggravated felony is subject to mandatory detention. The immigration judge has the power to release that person from custody. And so the consequence and then removal, forcible removal from the United States is fairly likely. After that, it's not guaranteed, but pretty likely. And so the consequences are pretty intense. And so people have to devote a significant amount of energy and resources to determining, is this person who is not a U.S. citizen, somebody who's been convicted of what Congress defined as an aggravated felony or not. So defense attorneys generally tried to avoid removal or having their clients removed. And despite common misperceptions, there are lots of ways in which creative lawyers can actually successfully intervene on behalf of clients, even clients who have a criminal history. And I think this goes to the fact that not all crimes are made the same. Murder is certainly not jaywalking. It's also not the equivalent of entering the United States without the federal government's permission. And entering the U.S. without the federal government's permission is a crime. It's been a crime since 1929, a federal crime. And people who have been convicted of federal immigration crimes make up a fairly substantial number, actually, the single largest percentage of prosecutions in federal courts nationwide, going back actually to the not the Reagan years, to the administration of George W. Bush, have been people who are being prosecuted for federal immigration crimes. And so this is a large percentage of the work of federal prosecutors, federal defense, public defenders, so federal defenders, federal judges, as well as all of the sort of enforcement aspect of agencies that go into feeding people into the federal criminal justice system. But in addition to the legal proceedings that are happening in the immigration courts and in the federal court system, we also see that the state court system, the role of immigration status has been playing a really significant role, especially in the last 10 years. And March 31st, 2010 is a really significant date. And I mentioned that simply because I was yesterday, or the 10th anniversary of that was yesterday. And that's an important date because that's the date that the U.S. Supreme Court issued a decision, with a rather landmark, game-changing decision called Padilla versus Kentucky, in which the court for the first time came to the conclusion that the Sixth Amendment right to effective assistance of counsel actually requires criminal defense attorneys to advise their non-citizen clients about the immigration consequences of a conviction. And this has meant that criminal defense attorneys and prosecutors and judges working in the state court system, which is the vast majority of attorneys who work in one aspect or another in the criminal justice system, have actually had to engage with immigration law, figuring out whether this defendant is actually a U.S. citizen or not. Is this person facing some criminal prosecution for a crime that is going to result in adverse immigration consequences? And so the bulk of that obligation certainly falls on the criminal defense attorney. But of course, the criminal defense attorney is interested in negotiating out of those problems, or should be at least, for their clients. And so that means that it reverberates the prosecutor and then judges who oversee these interactions. At the University of Denver, we had the great fortune of being able to host Jose Padilla, who's the named individual in Padilla versus Kentucky, in 2016. We had him on campus to talk about his experience. As far as I know, it's the only time that he has publicly reflected on the experience he had, both through going through the criminal justice system, but also seeing the impact that his willingness, his interest in contesting the lower court decisions had when his case got up to the U.S. Supreme Court, and getting a sense of his role, his understanding of the impact that his predicament had on the face of the criminal justice system and defense attorneys and prosecutors all around the United States. This work comes up in immigration courts. It also comes up in state courts, federal criminal courts, and at each point of the way, for the folks who are actually going through the process of the immigration court process or the criminal court process, for those migrants, the stakes are fairly high. There's the possibility of pretrial detention. There's the possibility of post-conviction imprisonment. There's the possibility of being detained by the Immigration and Customs Enforcement Agency. And then there's obviously always the possibility of forcible removal from the United States. And it's that last feature, that enforcement aspect of the criminal immigration law intersection that has been my focus for several years now, and is the focus of my most recent book, Migrating to Prison. Um, so let me speak a little bit about that and give you a little bit of context about what it is that I'm referring to. So outside of Philadelphia, there's an old nursing home that instead of caring for the old these days, it detains the young kids who came to the United States with their parents. And in the hallways of this old nursing home, which people now enter, but are not allowed to leave on their own of their own volition, a little boy named Diego went, in the words of an immigration judge, went from diapers to detention. When he was just 1 year old, Diego's mother, Wendy, decided that life in Honduras had become too dangerous for them to stay. And so, like people from all over the world have done for generations, Diego and Wendy made their way to the United States. Now, if you're afraid for your life, and if you're physically in the U.S., federal law is clear that you can ask for asylum. Does not matter where you came from. It does not matter how you got here. And that's exactly what Diego and Wendy did. And within a few days, they found themselves locked up in that Pennsylvania immigration prison. So they were two among 400,000 or 500,000 people who every single year will find themselves behind barbed wire or behind a steel door while the government decides that they're going to be allowed to remain in the U.S. And instead of a match between a prosecutor on one hand and the defense attorney on the other hand, imprisoned migrants usually walk into court alone. The vast majority of these folks are standing in front of an immigration judge across from a prosecutor without a lawyer by their side, and it's a high stakes battle in which they're fighting essentially with what I think of as having their hands tied behind their backs. And as the courts deliberate, the days obviously pass, and often that takes months or years. For Diego, he went from being 1 to being 2 to being 3 years old before he was able to get out of that Pennsylvania facility. So they're kids. They're kids. Sometimes they're 17 years old. Sometimes they're 17 weeks old. They're women. Sometimes they're traveling alone. Sometimes they're mothers who came to the U.S. with their kids, like Diego and Wendy. They're men. Some who are hoping to support families back home. Others who have green cards and decades in the United States, like a man named Kamar Samimi, who was living in the Denver area for many years, for 40 years. In fact, he'd been in the U.S. for 40 years, and one day, a few years ago, Immigration and Customs Enforcement agents went by his house. They arrested him, took him down to a private immigration prison in suburban Denver, in Aurora, Colorado. Maybe 5 miles from where I'm at right now, in Denver. And within 2 weeks, he was dead. The government never did get around to deciding whether he ought to be deported from the United States or not. So as we go through the immigration court system, we see that there are people who sort of run the gamut of society. People who have engaged in nothing more heinous than being children who have been brought here by their parents to request protection, to request life-saving protection. And then there are people like Mr. Samimi, who had actually been convicted of a drug crime. He had been a drug addict. He was convicted of that offense years ago. And then he did his served his sentence for that. I forget exactly what it was, but it was something fairly minimal. And then he actually got medical care. He was under a doctor's care to continue to sort of live with his addiction, and he seemed to be doing fine for many years. It was actually the withdrawal from the methadone that he was taking that actually ended up killing him. When he got to the Aurora facility, they stopped giving him the medication for his addiction, and so things went downhill. pretty quickly after that. But these days, what we're seeing is that we have the Immigration and Customs Enforcement Agency holds about 35,000 people as of last week on a given day. So March 28th, for example, they reported having about 35,000 people in their custody. There's another 3,000 or so kids who are held by a different government agency called the Office of Refugee Resettlement, which is part of the Department of Health and Human Services. And all of these are people who are held in facilities that are designed to hold large numbers of people in fairly close quarters, meaning that the kind of physical distancing that I've been practicing or trying to practice for several weeks now, that I think many of us have been trying to practice, that explain why it is that I'm speaking to you from my home and not from the university, are impossible by design, by the design of the facilities in which these individuals are being held. And so we see is that it's in many of these facilities, even the sleeping areas are not 6 feet apart. They're closer than that. So people can't even rest at night following the CDC's guidelines, nonetheless move to the dining hall, for example, where they're moved in large groups in lines, oftentimes only inches apart from one another. And so we've seen a flurry of lawsuits that have been filed in the last couple of weeks, aiming to release individuals, to force the federal government to release individuals from confinement. And the Immigration and Customs Enforcement Agency has broad discretion to release anyone who's in its custody. Barring that, there are some legal claims that have been brought. The Fifth Amendment Due Process Clause, for example, allows for or requires that anytime that the government detains somebody, that they avoid detaining those individuals in a context in which they might suffer. They're at substantial risk of suffering a serious harm. There's been at least one lawsuit filed against the Immigration and Customs Enforcement Agency by individuals who were being held at a immigration prison in California. That has been successful in convincing a federal judge to order their release. There's been a litigation in Philadelphia has also been similarly successful. One of the cases that I'm most interested in following is a case focused on three immigration prisons that are used exclusively for families. There's one in Berks County, Pennsylvania, where Diego and Wendy were held a few years back, and then just two others in Texas. That case is interesting to me in part because the Academy of American Pediatrics, the AAP, which is the largest, like 67,000 member organization of pediatricians, largest organization of its kind in the U.S., I think maybe the world. Has weighed in quite strongly on the inability of the Immigration and Customs Enforcement Agency to house these children and parents in reasonably safe conditions, and have joined the families who are suing to try to force the government to release them. And so we're starting to see a lot. The question that I have is, will this happen fast enough? Because of course we have already seen that in a number of jails and county jails and state prisons, some inmates have started to die. The first federal prisoner to die a few days ago in Oakdale, Louisiana. Now that individual was held in a federal prison, but it's that prison is part of a larger prison complex in which there's an immigration court and also an immigration detention center that is run by the Immigration and Customs, or run on behalf of the Immigration and Customs Enforcement Agency. So they're different buildings, but they're on the same campus. And so I'm not particularly convinced that the separation of these facilities will protect, will keep the COVID-19 from moving from one facility to another, because of course this is the same community. The guards are going in and out. They all live in the same community, and so wherever the initial source of contamination is, doesn't really matter, because of course there are some people who don't get to leave, but then there are others who do get to leave, and they're all susceptible. I mean, and so whether it's the families that are home, or the workers who are going to staff the prison, they're all susceptible. We're starting to see that actually a lot of employees, or a lot of a lot of the cases of COVID-19 that are being found inside of state and prison systems are actually among employees, among guards, and so that certainly is a very real concern, and one that all of the court decisions that I've seen so far in the last couple of weeks are taken into account, because this pandemic is a concern of community health, right? Of public health, not simply of the health of an individual person. And so we'll see how ultimately all of this shakes out with COVID-19, but how it shakes out in the context of the immigration prison system, and of course what implications, if any, that has for the long term. So I'll stop there. And certainly invite questions, and we can see where the conversation goes from there.
Great. Thank you, Professor Garcia Hernandez. We're going to start then. May will start with like the first three, and then I'll take the next three, and we'll get through. Yeah. Right now it's like 2:03, so we have about 27 minutes, so we have a good chunk of time. So thank you. May?
All right, so we'll jump into our questions from the Zoom chat. Professor, do you know how many detention centers Colorado has? And does the immigration clinic that's at DU work with any particular detention center?
Yeah, so there's one principal detention center here in Colorado, the Aurora facility, that I was mentioning earlier, and our clinic does work with folks who are there, primarily by representing people in bond hearings. And so what that means is a hearing in which they're requesting that an immigration judge release somebody from custody, so that the rest of the immigration court process can happen while the individual is living out in the community, as opposed to living inside of the facility. The other way in which our clinic is involved with folks who are detained there is by identifying some of the more complicated areas, some of the more complicated questions of the intersection of criminal law and immigration law, how it is that a particular criminal history affects immigration affects the ability of somebody to stay in the United States. And those folks have moved beyond the bond process, and either have not been able to convince an immigration judge to grant bond, or have not been able to pay whatever the bond amount was. The way that our clinic identifies people is primarily through referral system, through the Rocky Mountain Immigrant Advocacy Network, an organization based here in Denver. It's usually referred to as REMAIN, the acronym. It's the largest immigration legal services organization in the region. And we have a really strong relationship with them in various capacities. Our graduates, staff there, some of the staff there. We have the folks from REMAIN on campus quite regularly to speak in classes or to do panels. They actually have social workers on staff at REMAIN as well that work inside the Aurora facility. I've had the great fortune of having some of them speak at the University of Denver as well, to talk about the work that they do to support the same clients that from the lawyer's perspective are being assisted through the legal process. and actually, our students are. I was just talking to a student recently about the way in which COVID-19 has affected her work in the immigration clinic, and it has had some pretty significant consequences by they can't see their clients in person anymore. They're trying to put together applications and bond packages through phone calls with family members and phone calls with detainees, and of course, hoping that the last time that they were in the facility, they weren't contaminated. There has now been I forget, 1 or 2 cases of confirmed COVID-19 among the staff. There were about 10 individuals who were quarantined for over a week. And in recent days, we've seen an unusual amount of number of people released. I haven't been able to really get a great number on a great sense of the number of people released. The reports I've gotten have been really divergent, and so I hesitate to share those. But it has been an unusually large number of people.
Great, thank you. Can you talk about any immigration law training at Denver Law that's not necessarily from the criminal law side?
Yeah, so we also have asylum class. We have a class on human trafficking specifically, and then we have externships that in which we partner with local nonprofits that focus on on immigration work that has nothing to do with criminal side of things. I know best the intersection between criminal law and immigration law, but for example, the JMLAC, the Justice Mercy Legal Aid Clinic, is an organization that is run by a former graduate of ours that's based here in Denver, that takes students every semester that I've been here, at least, and they mostly work on what we call family-based petitions. So petitions for visas, for lawful permanent resident status, based on family relationships. There's lots of naturalization work, lots of community organizations that help people who are going through or who are interested in going through the naturalization process. Our students regularly staff those clinics. They often do through the intake that precedes the work of lawyers. When DACA was on the chopping block a few years ago, but it was still possible to file for DACA or file for renewal of DACA. Our students were really active in participating in DACA clinics. We actually organized a number of DACA clinics on campus to help people either apply initially or renew those. So there's lots of other kinds of work, and just because I didn't talk about it doesn't mean it's not happening.
Right, thank you. And the last question that I'll have for you is, when you're talking about aggravated felony charges, are we assuming that the immigrant is here legally or illegally? And is there a difference in the legal process for each of those?
When we're talking about an aggravated felony conviction, that is almost only relevant for people who are here with the government's permission. Usually we're talking about people who have green cards, what we call lawful permanent residents, formally. But most people just say green card holders. So those are people like Mr. Samini, 40 years in the US, business owner. There are people like a guy who I write about in the book, in my book, named Jerry Anamijo, who was raised in the U.S. He graduated high school not far from where I did in South Texas, and then he joined the U.S. Army. He gets sent off to Iraq, and one day he's patrolling in a tank, and his tank goes over an IED. The IED blasts right to the bottom of the vehicle. He gets a leg injury and PTSD, so he gets sent back to Texas to get better. And he doesn't get the help that he needs, so he starts self-medicating with drugs. Eventually the police catch up with him. And so he gets convicted of possession of marijuana twice. I think it was 2 or 3 times. I forget. And he's going through the criminal justice system through a special court set up in South Texas for veterans. It's not unique to South Texas, but that's where he was. And when he's doing exactly as he's supposed to be doing, and one day he's just stopped showing up, and it turns out ICE had arrested him because even though he was in the U.S. for all but I think the first year of his life, even though he was in the U.S. Army, or he had been in the U.S. Army, even though he was able to drive a tank on behalf of the United States, put his life on the line on behalf of the U.S., he wasn't born in the U.S. He was a permanent resident. He was born in Mexico, so he was a permanent resident. He had a green card. That made him eligible to join the army, but it also meant he was susceptible to deportation. And so those are the folks who we're talking about primarily when we're dealing with the possibility that criminal activity affects immigration status. For folks who are in the United States without the government's permission, the government can remove those people without needing to deal with the messiness of figuring out, is this crime something that is defined as an aggravated felony or not? So it's a lot more straightforward. Those are the people who we're seeing in federal courts who are getting prosecuted for crimes like illegal entry and legal re-entry. When I said earlier, that's the bulk of the largest category of crimes that are being prosecuted in federal courts, going back to the Bush years, are immigration crimes. That's those people. So if you remember back to 2018, the summer of 2018, the family separation policy was happening. The parents or the kids were being sent off to facilities run by the Office of Refugee Resettlement, but the parents were being prosecuted in federal district courts for the crimes of illegal entry or illegal re-entry. And so there are different processes, but high stakes nonetheless for both.
All right. Thank you. Yvonne, you want to go ahead and take over?
Thank you. Regarding the practical experience that law students can get, can you give us like examples of some of the common externships, internships, crimmigration, or the other immigration law, and what the students actually do?
Yeah, so the Rocky Mountain Immigrant Advocacy Network, Remain, is an organization that we have really close ties to. I referenced it already in terms of the clinic specifically partnering to identify good cases. And good cases, to be clear, tend to be cases in which the private bar is not particularly interested, oftentimes because private attorneys are running their own businesses, right? So they need to be paid by their clients. If people don't have the funds to pay for a lawyer, then most of the time they're not going to have a lawyer. So we don't charge. The clinic doesn't charge clients, and so that's a useful way of identifying people, but also the complexity. But Remain, at Remain, folks are working in various programs that Remain has. They have a children's program, so they're sometimes working with kids who are going through the immigration court process. They have a detain program. That's the one that I know best for obvious reasons. And so they're working hand in hand with the attorneys who are going into the detention centers on a daily basis. I've had students who who I've worked with and partnering with Remain to develop what are essentially cheat sheets, I think, of their practice guides for the lawyers that work with Remain to help them figure out the complexities of the way that criminal law and immigration law interact with one another. Let's see, where else? There's Catholic Charities that does mostly family-based immigration and work. The International Rescue Commission committee does mostly refugee resettlement work. The Lutheran Immigrant Refugee Services also does mostly refugee assistance, and they help folks who are going through asylum process as well. And so all of those take on different substantive focuses, but they also have different roles for the students. So for the students who are working in the detention center with Remain, they're meeting with clients inside a jail. That's very different from the folks who are helping do a family-based petition to see if they can get if one person with a green card or one U.S. citizen can help their spouse get a green card. There, you're meeting with clients on an appointment basis in an office, right? Somewhere in Denver. There, you're talking with people a little bit and collecting a whole bunch of evidence, a whole bunch of documents about how long people have lived here and work histories, things like that, and then putting that together and sending it off to the appropriate federal government agency. So the work differs a lot. One of the things that's really nice about Denver, the Denver legal community, is that we have an immigration court here. We have a detention center here that has its own court, but we also have the federal government, the headquarters of the regional federal government agencies that deal with immigration benefits. So the U.S. Citizenship and Immigration Services that decides who's getting visas, for example. There's an office here in Denver that every semester has some of our students externing at. So you get the government side experience there. And that's a feature of the fact that, you know, this is the center of the legal universe, and we're the only law school in town, and one of only two. So it means that we have a fairly substantial presence in all of these settings.
Thank you. Are there points where your scope of immigration law deals directly with reforming the immigration laws in the country?
Yeah. So I'm fairly critical of the way in which our immigration law enforcement system operates. That's primarily my focus, but I don't think you can divorce the enforcement side of things without also dealing with the substantive laws. And so long as you have a really a broad ranging list of reasons why somebody can't be allowed into the U.S. or why somebody merits being removed from the U.S., then you're going to have a fairly large enforcement apparatus as well. And so for me, those two are certainly, though my focus is on the enforcement side of things, it's never possible. It's never even desirable to disentangle that from the substantive laws that Congress or policies that agencies have adopted over the last few decades.
Okay, May?
So earlier, you spoke about Padilla, but are there more recent Supreme Court cases or cases that are potentially going up to the Supreme Court that are worth keeping an eye on related to the intersection of criminal and immigration law?
Yeah, actually, as soon as I get off this call, I'll get back to the work of updating my first book, which I'm working on the second edition now. But that is basically a large compilation of cases that are relevant to the intersection of criminal law and immigration law. And that book came out in 2015, so there's been an enormous amount of development in the intervening 5 years. I think I've never counted, but my research assistant counted a few months ago, and apparently there's something like 1,000 footnotes in that book. So there's lots to update. Especially when it comes to actually the aggravated felony area. The Obama administration was really quite forceful about expanding the reach of the definition of aggravated felonies. The Supreme Court, I think, it's not surprising to me, but I think it's surprising to lots of people who don't think about this every day, was actually quite reluctant to go along with the Obama administration's claims for about the broad scope of the aggravated felony definition in their view, going so far as to find one section of the aggravated felony definition actually unconstitutional a few years ago. In a decision called Sessions versus DiMaia, which actually was decided under President Trump, but was started under President Obama. So yeah, there's no shortage of updating as I'm reminded every week when my research assistant sends me new material that I need to take a look at to figure out whether I need to incorporate it into the second edition of that earlier book.
Great. Well, we have just about 10 minutes left and 3 more questions. So I have one and I'll let Yvonne take our last 2. Can you speak to the rights to safe or humane treatment that people in detention centers have, and maybe a little bit about where those rights come from?
Yeah, so the most important, I think there are 2 important sources. One is statutory. So statutes are just the laws that legislature enacts. So the Congress enacts. In the immigration context, it's called the Immigration and Nationality Act. And the other is constitutional, and primarily the Fifth Amendment due process clause, which ensures that before the government deprives somebody of life, liberty, property, less important in this context, but life or liberty, that they be provided with some kind of procedural protections in which they have a meaningful opportunity to engage with their accuser, with the government. And so that's where we see some of these court cases recently that I was referring to really focus in on the amount of risk that the government is exposing detained individuals to by holding them in facilities where it's either impossible or impractical to take the basic preventative steps that are necessary to avoid contamination from COVID-19. But we see this the due process clause come up in far more ordinary, mundane contexts about access to counsel, for example. There's no right to appointed counsel in the immigration court, meaning that if you have the ability to pay for a lawyer or are lucky enough to find somebody who's going to work for free, then go for it. You're welcome to have a lawyer, but that means is that the vast majority of people who are going through the process are doing it by themselves. So some litigation in recent years has been trying to use either the constitutional provisions, the due process clause, or some statutes to expand the scope of appointed counsel. And there's been some success in the context of people who are mentally ill, who are so mentally ill that they're actually incapable of engaging with their own lawyers to advocate on their own behalf. And that's been through a statutory route, actually, through something called a law called the Rehabilitation Act. Sadly, most of the constitutional claims have failed, even the claims on behalf of children who are detained and on their own have failed. And so there's plenty of room for creative advocacy moving well into the future.
I'll move the last question up because it fits into what you were just saying, Professor. Are there any efforts by the legal community underway to change laws and policies so that children facing deportations are guaranteed representation in the immigration court?
Yeah, I think that the immigration legal community has been quite adamant for many years that children in particular should not be going through the immigration court process on their own. And that's mostly what happens these days. And so there's not a question of sort of the unity or agreement on the proper advocacy. It's a question of success. that has, as I suggested, that's had limited success through litigation. But I think one of the important things to remember is that lawyers don't advocate only inside courtrooms. Lawyers advocate outside of courtrooms just as much, just as vigorously as we advocate inside of courtrooms. Lawyers are legislators. Lawyers are staffers for legislators. Lawyers are policy advocates. And in that sense, I think the while the litigation has been creative but stalled, advocates have been turning to legislators to expand the reach of access to counsel. And so here in Denver, for example, a few years ago, advocates from a number of sort of sectors of the community gathered together to help push the city to create a legal defense fund for people who are going through the immigration court process and who don't have the ability to pay for lawyers. So there was this was actually successful at the municipal level in Denver to get the city to create a defense fund, to get some funding for it. To essentially hire lawyers. The University of Denver has been involved with that. I was personally involved with the development of that. And in recent months, there's been an effort to expand that statewide. The legislature shut down recently for obvious reasons, and it just reconvened. And I don't have a clue what is going to happen now, given the state of uncertainty, just generally in which we exist.
Thank you. And the last question: do Denver law students learn trauma-informed or cultural awareness skills, or addressing how to deal with Spanish-speaking clients in the immigration criminal law clinics?
Yeah, so I think there are a number of ways in which I think many of us try to take some of those considerations into account. One is through the live client experiences and in the clinics in which people are obviously being exposed to clients who have many instances suffered through trauma before getting to the U.S. In some instances, suffered trauma since getting to the United States. I think the folks who run our clinical programs are well aware of that, and do take into account not only the way that trauma affects clients, but also the way that trauma affects advocates. And it's important not to minimize, right, the fact that secondary trauma is a truly concerning consequence of advocating on behalf of some of the most marginalized members of our communities, and one that shouldn't be overlooked. More broadly, I think many of us, even in courses that are not related to the clinical program, take into account and value the importance of incorporating social justice work into the courses that we teach. Several years ago, students actually organized themselves to promote something called the Pledge for the Public Good. They actually created it, and what it is a call for faculty to incorporate social justice into all of their classes, and then they every year they ask us to voluntarily agree to do so. There's no requirement that any of us do so. I think most of us do so. I certainly do, and I think that's true of most of my colleagues, because I think we take seriously the role of the lawyer as an agent of social change. We're not simply here to improve our own circumstances. We're, as lawyers, we have an enormous responsibility, an obligation to advocate for others. And with that obligation comes an enormous responsibility. I think most of us take that seriously in our own lives, and also in the teaching that we do for the next generation of students.
Thank you so much, Professor. We
Thank you all.
listed your books and your email in case there are other questions that students have and didn't have time to ask or didn't want to ask in front of the group. So thank you to everyone who participated. Please look forward. May, can you tell us a little bit about upcoming attractions?
So I sent out an email to everyone, but just in case you didn't get it, on our website, we also have an environmental law panel that will be happening next Wednesday, April, not March, next Wednesday, April 8th at 10 a.m. And we will also be hosting some current student panels as well. So you can hear from current Denver law students, wide variety of years, part-time, full-time, to be able to get additional perspective on the Denver law community.
Thank you all so much. Thank you again, Professor.
Yeah, thank you all.
Take care, everyone. Be safe.
Thank you.